So good evening, everyone, and welcome to the March month's Max Weber lecture, where we are very happy to receive Helena Alviar García from Sciences Po, who is also staying with us at the EUI for the whole month as a Fenn Brodell Fellow. She and her work will be presented to us by Noor Bengelab, who will I'll just give the floor to you, who will tell us more about the speaker today.
Thanks. So I'm going to repeat what Yogo just said. Okay, it's really nice to receive today Professor Helena Alviar García for this nice Max Weber lectureship entitled Granting Rights to Protect Nature, Possibilities and Limitations. So her work brings together several disciplinary traditions, especially the one of political economy in relation to the law and legal phenomenon, to study them and to understand how they participate to shaping our economical structure. And among other things, Professor Garcia wrote extensively on law and development, property law, social and economic rights, feminism, and transitional justice. And she also had like a thriving career because she was teaching and holding position in South America, in the United States, in Europe. She was, among other things, the dean of the University of Los Andes in Bogota, where she also did her undergrad degree. And she's since 2019 professor at Sciences Po Paris. And she, as Yoho just said, is today with us for the next month as a Fenn Brodell fellow here. So if you want to talk to her, maybe she's going now. This is the time or never. And I will not occupy all the space, so I will let you the floor. Thanks.
Okay. Thank you very much. I've been told that the room has bad acoustics, so I would really ask the people way there that if you can't hear me, please just wave. So I wanted to thank Yuho, I hope I'm pronouncing the name correctly, for inviting me to give this talk, which is such an honor, and also for Noor for her very generous introductions. Sometimes I think I've worked on too many things, you will tell me. And I'm going to present today recent work. So it's not work that I've done, but it's very linked to things that I have done throughout my career. And so I'm going to do that. And I'm going to ask Noor to remind me when I think I'm going to talk for about 40 minutes maximum to allow for a conversation. And, if you want me to develop something, pushback, critique, whatever. So Noor, if you could remind me when I have 20 minutes have passed, and then when 10 and 5. Please, sorry, I should have asked before, but okay. Okay, so let's dive into it. So the order of the presentation is the following. At the beginning, I'm going to give you the general goals that I have while doing this. Then I'm going to do the introduction about how I got to this topic, why I think it's important, what I'm trying to do with it. Then I'm going to describe the idea, the centrality of rights, mostly in Latin America. Of course, this presentation is about Latin America and Colombia specifically, because the case I'm going to bring is a case that was adjudicated by the Colombian Constitutional Court in the year 2016. It's the Rio Atrato, when the Rio Atrato was granted rights. But I think that many of the proposals that I'm trying to pull through here are proposals that I hope or think that could be translated to other jurisdictions. Then I'm going to describe the ruling a little bit, not too much, because I realize that not all of you are lawyers, but I think that they're interesting things to understand this movement towards granting rights that is going on in many places. And then I'm going to walk you through the ruling by talking about the possibilities, but the internal and external critiques that the ruling has. Then I'll end with some conclusions and we'll open it up for conversation. So One of the things that I've started to do recently is that less recently than the rights to rivers, but very recently is a law in humanities, as you will see. So this was an exhibit of a Colombian artist. Her name is Delcy Morelos. It was an exhibit. This photograph in particular, I think, is of the exhibit in New York, but the exhibit was in Paris, and that's where I saw it. At the initial part of the exhibit, there was a phrase that she wrote, which says, in Andean so coming from the Andes, ancestral traditions, the human being is living earth. I am a body, I am earth. In the exhibition space, the earth expresses itself. It is the center and the mirror of what we are. El oscuro de abajo, so this is the name of the installation, is a large installation composed of earth mixed with cinnamon and cloves, which occupies a large parts of the walls, floor, and ceiling. So there you can see it. I mean, the images is imperfect, and we will have some issues with the images here because that's not my area of expertise, but I'll try to explain everything. According to Morelos, I create an experience for the human senses with images, smells, silences, tastes, textures. I like synesthesia, and I am moved by the alchemy that awakens different emotions in each person. I speak to the human body. I take it through a sensory threshold to the dimension of the sacred, to the void, to the primordial terrestrial one. Through her work, she is criticizing, and this is going to be central to this talk, the idea of domination of humans standing over land. And this is one of the interesting things about the work, which is it's not on the ground, it's horizontal, controlling it. She describes her art as influenced by witchery and not rationality. Delcy argues that the earth is fragile and we contain it. We are part of it. This domination over nature that some of us or some think brings an immense sense of solitude, according to her. And if you want to know a little bit more about the exhibit, which was absolutely fantastic, I can say a little more about it. I'm very interested in exploring how the language of rights captured the imagination of both the center and the left in Latin America, at least since the 1990s. What have been its possibilities and limitations? So originally, I've done work on social and economic rights. We can have a conversation about that during the question and answer period, but also the equality clause, which I'm going to talk about a bit tomorrow. Now, why would I think that it's problematic that both the center and the left have embraced the idea of rights? I mean, for a range of reasons, but one of them is that people see it as the only language of emancipation, crowding out other possibilities. So just to give you a short story, during the Colombian peace process, I taught a course that was about the specific items of negotiation that FARC, the guerrilla movement, and the Colombian government were engaging with. And it was a seminar, and there was a leader of a peasant organization who was taking the seminar. So we divided the topics of the peace agreement, and each student had to write a reaction essay about each piece. So the first topic of the peace agreement was actually agrarian property, or rural reform, it was called, if I'm not wrong. And this peasant leader wrote his reaction paper saying, the solution to the inequality of land distribution in Colombia is reforming the constitution and including a right to land for peasants. So completely captured his imagination. One could think about a million ways of solving the unequal access to land in Colombia, but because the language of rights had captured the imagination of many, the only way that could be translated was if there was a constitutional amendment and there was a right to land for peasants. We can talk a little bit about that in the question and answers. But also, the language of rights accepts as a premise both local and global capitalist forms of production, because it is about the market economy and the individuals within the market economy. And this is going to be very relevant in its relationship to nature. And finally, but we can talk a bit more about other issues, it interprets a particular problem less framed in relation to its structural causes, and this is going to be very evident when I talk about the Atrato River, and more as the consequence of what individual actors are doing or how individuals, even if groups of individuals, are being affected. Now, what am I interested in? I'm more interested in the ways in which we can use law, but use it, and critical thinking to mobilize ideas aimed at redistributing resources across class, gender, and race. And of course, between humans and nature, because it's the objective of my talk. Now, this has an environmental dimension in the ways that different communities are determined by or have critiqued the human-nature dichotomy. And I will talk a little bit about this throughout the talk. But I also want to use critique as an open space for collective action and for disruption, as a range of actors are placing limits on capitalist ways of production. So we can talk a little bit about that in the question and answer. Now, how did I come to this topic? So this is a picture of the Atrato River. It really doesn't make justice to the beauty of the river, but I went to the Atrato River for the first time in 2017, 1 year after the ruling. And as I was leaving my house, I told my son, I'm going to Quibdó and to the Atrato. Quibdó is the department's capital, so it's the main city. Well, and my son told me, well, Quibdó is a city like many other cities you see in Colombia. I mean, of course it's the poorest city. It has many particularities. But he said, what is truly magical is the river. And I thought, oh, that's his thinking. But actually it is quite magical, because it's not only, the river isn't only transportation, or it's only a place to fish in. It really is a place where there is culture, where there is, I mean, it is an entity on its own that fulfills many objectives for the population that is there. Now, this work that I'm doing on granting rights to rivers and its possibilities and limitations has to do with what Noor already generously talked about, my interest in law and development, so it's framed within that. The social and economic rights, because as I'm going to explain, it's very related to that. Gender, a bit. I'm not going to talk too much about gender today, but I will tomorrow. How we measure and understand environmental damage, for example. And this is the first step in a project that I hope to bring in. So I've looked at the Atrato, mostly because I went to the Atrato, but I'd like to go to other places in Latin America and test these ideas. Now, what are the theoretical interventions that I'd like to make? This is a installation by Muna Hatum. It's called Light Sentence, and I like it because it's about illuminating between spaces. So I actually, in the last few days, I've been hearing a lot about continuity or break, like that we're in a specific and very different historical moment, or if we are in a moment that has a continuity to what has happened before. We can take this after and during the end, but I'm very interested in understanding the granting of the right to a river, to the river Atrato. How much of it is a continuity and how much of it is it a complete break? Now, the court specifically said, this is a total break, and I'll explain that a bit, but I see more continuity. Then another theoretical influence is distributional analysis, which is the idea that we think that constitutional law is the most important thing, or we think that EU law is the most important thing, or we think, but actually there are a lot of laws in the background that are determining the possibilities or limitations of any specific law. So for example, economic development plans through administrative law determine the possibilities of constitutional law, but also of trade law, etc. Criminal law is going to specifically interact with the granting of a right to a river. Trade law is going to interact with the granting of a right to a river. But for example, local laws influenced by laws from other parts of the world. So just to give you an example, the fact that rules about caregiving and care provision in Italy can have an influence over migration, which is a work that a colleague of mine that I admire a lot, Hila Shamir, has talked about. Okay. Another influence is dependency theory. I'll talk a little bit about that, but of course, as a Latin American, like a person, leftist from Latin America, I cannot, ignore the inputs of dependency theory. And as you can see from my presentation, the dialogue between law and humanities is also really important to me. Now, the centrality of rights, which is, I'm going to go quickly here. But, again, we can take this during the question and answers. This is a photograph. Again, the quality isn't perfect. In my dialogue between law and humanities, one of the things that I have to learn how to do is to get better images, but I'm working on it. This is a picture. It's a photograph of a Colombian artist whose name is Juan Fernando Herrán. And it is of, this is actually in the city of Medellin, which is surprising. But it's the stairs that take people from one metro station to their houses, which are in, irregular housing in some other place. And the reason I included it here is because I think that I'm proposing that both the left, for example, the Bolivian constitution, which was very influenced by dependency thinking and included the rights of Mother Earth, and the centrist country like the one I come from, used both of them, set their hopes on the language of rights. There are other examples. I've looked less into them, but Venezuela during Chavez also had a very big content of rights. I don't know, I haven't seen the new Maduro ruling, so I'm not sure about that. I don't include constitutions that I would call more neoliberal in this analysis, like, of course, the Chilean or the Peruvian, which I know a bit more, but because I haven't studied what are the environmental clauses that they had. So this is about the center, which is a, Estado Social de Derecho, which is a Colombian, which is a negotiation between neoliberalism and state interventionism, and a more dependency-oriented constitution, which would be the Bolivian constitution. And if you want a little bit more detail about that, we can talk about it during the question and answers. Now, just as a recap, both the case of Colombia and the case of Bolivia that are not opposing completely, but are in two different political and ideas about the economy camps, I think would illustrate that rights are and have been the backbone of progressive constitutions that swept the region since the early 21st century. Although some were more redistributed than others, the language of rights was used for a range of purposes, including access to health, to a pension, to housing, and very importantly for our conversation today, the right to a healthy environment. So what I'm going to do starting now is like the most important or the central part of this talk, which is walking through the case of the Atrato River to see what were the characteristics of the case, what were the court orders after the case, and then what are its possibilities, the internal and the external critiques. Now, to start to talk about the case, I wanted to put this sculpture. It's a sculpture by a Colombian artist, again, sorry about too many Colombians. His name is Fernando Arias, and the name of this sculpture is called Agua que no has de beber, water that you shall not drink. And what he's trying to do here is to say, and actually it's the Andes Mountains, the place where in Colombia, where the most important source of water comes from. And what he's trying to say is that in Colombia, by granting so many mining licenses, so that's why the figure is in gold and you can't see very well, but there's some precious stones there as well. We are actually not drinking the water, but selling the water to foreign investment, etc. So during the past 10 years, there has been an increasing interest, as many of you, I'm sure, know, in studying, denouncing, attacking, and preventing environmental damage. I think it's something that joins us all, or many progressives now. Now, within this academic, political, and social movements, the adjudication of rights to rivers has been gaining force. And so, you know, there are cases in India, New Zealand, in many other countries in Latin America. The Atrato River in Colombia was granted a right in 2016, as I mentioned before. And between the year 2016 and the year 2021, more than 10 rivers have been granted rights in Colombia, including the Amazon, but also environmental like areas like moorlands, for example, have been also granted rights. Now, in these cases, at least in the Colombian setting, judges established that nature has personhood, that it is, in Spanish, sujeto de derechos. And this means that they can sue and be sued in court. They have the capacity to engage and enforce legal contracts, and they have the possibility to own property. And this is all done through an entity that represents their interests, it's called guardianes del río, or guardians. So one of the first very interesting things about the Atrato case is that it illustrates how ideas travel and are applied in the most diverse settings. So there are several things that have happened to aid the travel of these ideas, and I'm sure that those of you who work on environmental issues here will have other examples, but one of them is the establishment of the Rights to Nature Tribunal, fighting for the adoption of the Universal Declaration of Rights of Mother Earth, for example, in the United Nations, and many international conferences organized around the rights to nature that brings not only activists, but also they've done a tremendous effort of inviting judges, for example. In each place, judges have crafted a combination of existing principles in their own legislation. So sometimes you have constitutions that already establish the rights, specific rights. So for example, the Ecuadorian Constitution, the Bolivian Constitution originally didn't, but they crafted a law that was later incorporated into the Constitution. But in the case of Colombia, which is the one we're going to look into now, it was configured by a range of existing rights in the Constitution, not a particular one. Very interestingly, in the case of the Atrato River, Justice Palacios, who is the one who drafts the opinion, references New Zealand. So the guardianship figure, the people who are guarding the Atrato River, how it works, how it was configured, etc., was inspired by New Zealand, which I find incredibly interesting. Now, the Atrato is one of the most important water sources in Colombia. Not only is it the third most navigable river, but also it is situated in Chocó, and I was going to bring a map, but it forgot. And Chocó is one of the most biodiverse regions in the world. So it's just extraordinary, the amount of diversity it has. And as the river, and as I was telling you with the story of the first time I went, it plays a fundamental role in the lives of the communities that live on its banks, that are mostly Afro-Colombian, or we call them Afro-descendants communities, and also indigenous communities that inhabit the river, but experience extreme levels of poverty. So it's the poorest in a country that is extreme, that has high levels of inequality. People who live in Chocó are extremely poor. The Atrato has rich deposits of gold, platinum, and other minerals, which have been extracted for centuries. So the extraction part of the story has been there for a very long time. Large-scale mining, both legal and illegal, and this differentiation between legal and illegal is going to be very relevant in a second, as well as legal and illegal logging, have greatly damaged the river. Illegal mining, as you know, dumps high levels of mercury and cyanide to its waters, producing long-lasting health effects. And that is highly documented in the case. So the case to protect the river was brought to court by the Center for Studies for Social Justice, called Tierra Digna, on behalf of various populations living in the areas adjacent to the river. Tierra Digna represented mostly indigenous and Afro-descendant communities who had collective property titles near the river. So Colombia has been granting collective property for both indigenous and Afro-descendants since the year 2008, if I'm very bad with dates, but I think more or less. Now, plaintiffs filed for protection from the government through a very quick way to do it. It's called acción de tutela. This is a bit technical for those of you who are not lawyers, but it's very interesting because the acción de tutela, you can only invoke it if you have no other way of getting protection. So let's say if there is environmental regulation, if there are other ways that you could access a protection, you should do so. But the plaintiff said, we've tried, there's nothing we can do. The best way we can do it is if you protect our constitutional rights. So when it was decided initially, the first court, I forget how you call that in English, but the first court that made a decision said, we are not going to look at this because you already have tools elsewhere in environmental law, in other laws. But the Constitutional Court said, no, this is a case of grave human rights violations. It's not true that there are other ways of protecting it, etc. Now, very interesting topic about the case is that the plaintiffs only talked about illegal mining. So they said that illegal mining was damaging the river. Now, that's a very interesting point because legal mining also damages the river, but legal mining has environmental licenses, and so the plaintiffs could not argue that it was about legal mining. It was only regarding illegal mining, and I think that is going to bring some limitations in regards to what the court eventually said. Now, it was brought against, this is also a very interesting point when I talk about the possibilities, the critiques, internal and external. The aim was the Colombian national government and many offices within the government, so the Ministry of Health, the Ministry of Mining, the Ministry of Finance, the Ministry of Defense, etc. Entities at the local level, so Colombia is divided into departments, not states, so the state of Chocó or department of Chocó, etc. And the issue was that they were allowing illegal mining, right? So they were not doing enough to prevent the damage of the river because they were allowing illegal mining. And I'll come back to this in a second. Now, characteristics of the other characteristics of the case is that they claim that the delicate and unique environmental landscape surrounding the atrato was being placed in imminent risk by intensive and indiscriminate illegal mining and logging. So again, it was only about the illegal. Now, the legal also brings environmental degradation, but they were excluded from the ruling, from the about what they asked for. Now, the court, in a very long 168-page, although I have to say that it's not the longest of the Constitutional Court in the peace agreement had a 1,200-page ruling, but this was only 168. The court engages with traditional human rights interpretation in line with social and economic rights adjudication of the past 15 years. So this is a very important issue that I mentioned at the beginning. The judge makes a tremendous effort to say, I'm not doing something really crazy here. I'm going to do something that you're going to think is crazy, but it's not going to be as crazy because it builds upon social and economic rights tradition that we've had since 1991, which is when the Constitutional Court was started. So he said, effectively, there are violations of the right to health, the right to food, the right to water. In the case of the right to water, he invokes the Inter-American Court, which has granted the right to water. It has It brings also a synthesis of the history of Chocó, why it has been determined by the by extractivism since its early stages, etc. But the most innovative, in my opinion, move with more possibilities, although the less robust in terms of the ruling, is the link between the exercise of all of those rights, so the exercise of the right to health, the exercise of the right to water, et cetera, to culture. Judge Palacio states that the right to food is intimately related to the protection of traditional practices, which are a fundamental factor in the construction of the identity of the communities that have specific protection, which are Afro-descendants. The ruling also foregrounds the spiritual importance of natural resources and the environment for many cultures. These two arguments, the relationship between food and culture and special protection, pave the way for the term biocultural rights. So the justice, again, it's really interesting. I mean, for those of you who haven't read rulings, because it's not your discipline, it's very interesting because the Supreme Court justice is trying to, on the one hand, convince the other members of his tribunal that he's not doing something that is going to be considered too radical, too out of line, not obeying precedent, etc. And he is also trying to show that he's doing something a little bit different. So in this case, Palacio says at the beginning, it used to be the case that when the Constitution was set out in 1991, even though it had some content of the environment, there was still the idea that humans and nature were completely separate. So there was more like a developmentalist understanding of it. Then, this is according to the justice, right? This is the way he's explaining his position. Then the court moved to a more biocentric approach, according to the justice, where humans remained at the center, but future generations and the well-being of humanity was considered. And this is what he called step 2, biocentric. And then he says this ruling is completely different, so break, right? In the argument that I was telling you between continuity and break, he's saying, I'm breaking gently, right? Because I'm still talking about social and economic rights, et cetera, et cetera. I talk about the Inter-American Court, but I'm doing something radical. What is this radical thing he's doing? He is going to move the court to the ecocentric era, which means that nature does not belong to human beings. The ruling says men, but let's call them human beings. They are, belongs to Earth. So nature, where humans are the ones who belong to Earth, where nature is and should be a subject of rights, valued in and of itself because we're part of it, and not simply as a resource. So I'll say a little bit why I think that this is, even though it's the least developed part and a little bit fragile within the ruling, that's where I think there's an opportunity for disruption, but I hope to hear what you think about it. Now, just briefly, biocultural rights include all forms of life in a particular territory. This is according to the rulings. The diversity of cultures, practices, and language in a place, which I love the reference to language, and I'll say something quick about it in a second. The relationship of the inhabitants of specific place with plants, animals, microorganisms that contribute to this biodiversity. It hints a little bit at the power-knowledge relationship, that we should be celebrating other ways of knowledge, that traditional ways of knowledge are also contributing to this domination of humans, now a separation between humans and nature. Beautiful one, the spiritual and cultural significance that nature plays for the communities. And then finally, he couldn't not do this, the legal and public policy tools aimed at the conservation and protection of this relationship. So as you see, it's a highly complex set of ideas in the term biocultural rights. Okay. Now, very quickly, after this analysis, the court recognizes the Atrato River as a legal entity, as I told you. The orders are really specific, and we can discuss a little bit about the orders when I finish, but I'm going to give you some examples. It demands that environmental agencies and municipalities develop a plan to decontaminate and restore the Atrato River. It establishes the design of a comprehensive plan which involves the military, and it's a very important part. There's a heavy-handedness on the military and criminal law to eradicate illegal mining within the following 6 months. The ruling, as I told you, is of 2016. The consolidation and development of a comprehensive action plan to recover traditional means of subsistence and food production, a redrafting of the mining code. So it has some others, but then, okay. Now, what are the possibilities of this ruling? Which I'm going to talk about in a second. So the case marked a turning point in the way nature was thought and dealt by the judiciary. That's why after that, there were many other rulings, not only of the Constitutional Court, but of administrative courts, the Supreme Court, granting rights to nature. There is a robust description of the dire conditions of the river and its effect over the people who live close to the Atrato, and placed the spotlight in a region that had been forgotten for a very long time. It brought local and international attention and has been consistently celebrated as an innovative, progressive ruling. Furthermore, granting rights provide fertile grounds to recognize the needs not only of a bank of water, but of the citizens who inhabit it, and so those are the possibilities. It accepts the separation of human and nature is artificial, as I already said, and it includes the figure of the guardianship. So now I'm going to talk a bit about internal and external critiques of the ruling. So this is a shroud made by Colombian artist Doris Salcedo, and it's made of rose petals. And the reason I brought it here is because I think that the internal critiques are trying to meddle a bit with the fabric of what the ruling did. So a progressive ruling marks the beginning of a struggle and not the end. I think I'm going to take a bit more, but not too much, actually. Marks the beginning of the struggle and not the end, as the ruling clearly demonstrates. Despite the possibilities that I just mentioned, the results, and I'm sure many of you can think about it, have been disheartening. The institutions in charge of following the court orders are typically understaffed. The Ministry of the Environment is weak, particularly in relation to other ministries that were called upon. So, for example, the Ministry of Defense or the Ministry of Finance, and therefore is constantly overruled. Guardians had been working pro bono, listen to this, until June of last year. So there was no resources granted to the guardians to advance the orders of the court. And also the code regulating how the guardianship body moved has been very contested and hasn't been established. The coordination between national and regional actors is almost non-existent. The ruling has been, one of the things that the ruling has, as I said before, is that it relies a lot on the military. And I was just in preparation for this talk, I was reading that one of the big environmental disasters that is happening now is that the military once in a while say, oh no, we have to take, we have to end illegal mining in El Atrato, and then they take the illegal actors, or they either to jail or I don't know, they escape, but then the machinery is left beside the river. So there are lots of places where the military has ended, or the presence of those actors, but the machines per se are there. So it's continuing to do the damage. Now, in terms of the external critiques, and this is a work of a Colombian artist, her name is Johanna Calle, and this is many ways in which different indigenous groups, so you can't see it, but it's words in which an indigenous group call the different words in which a specific indigenous group names water or rain, actually. And so I thought that it would be really interesting to show the external limitations. So the limitation of the language of rights as adequate tools for emancipation, I talked about this at the beginning. One of the things is that harm is mostly described in terms of individuals, so violations to the right to health, to water, etc., and the protection of groups that are in the margins, and less about a conversation about more structural ideas. It required that one of the interesting things that I hope you maybe saw is that the court orders are only directed to the state. Only. So the state has to do this, the state has to do that. It's either military or finance, etc. But the private mining companies, who are also contributed to, the deplorable conditions in which the river is, are completely left off the hook, because human rights discourse, language, in the case of Colombia, has to be directed to state protection, or generally, I would say. Then because it is so individualized, etc., it also has an interesting relationship with property. So if you took biocultural rights seriously, you should transform the understanding of property, less individual and much more collective. But the ruling says nothing about that. Again, as I was preparing for this talk, I reviewed again if the ruling says something about export-led growth, and it's linked to mining, extractivism, etc. The ruling says nothing about that. So if you take dependency theory seriously, which I do, the ruling, willfully or not, ignores environmental degradation that is determined by the economic development model that it quotes growth and the centrality of extractivism and the position that Colombia occupies vis-a-vis the world. And we can talk a little bit about mining. So my conclusions are that this judicial intervention is situated in the middle of a paradox. Colombia is a country that up to now, except for the current government, which is a leftist government, has embraced an extractivist economic model, a model that contains nature as a resource, separate from humans, producing capital accumulation out there to be exploited. And so the right to a river is not really going to compensate that. It's important for sure, but there are other areas of law that should be rethought in relation to this, like mining law, like the court actually said it in a way, corporate law, criminal law, trade, investment law, and we can talk a little bit about that. So there is no denying that the content and structure of the ruling, which granted rights to the Atrato River, is creative and marks changes in the way the relationship between nature and humans is structured, particularly in the term biocultural rights. But if we took the term biocultural rights seriously, we would be changing both ideas about export-led growth and ideas about property, ideas about individuals, ideas about our relationship to nature. So thank you very much.